In terms of evidence and aggravation, Miss Boykin, at a prior hearing, you didn't have the case at the time, but it was Mr. Herzog who made representations that this case involved gang.
All right, strap in, because today's case cranks sovereign citizen fantasy to maximum volume. This isn't the usual rambling about imaginary rights or made-up jurisdiction, it's far more serious. This former correctional officer lost her job after being accused of trying to sneak prohibited substances into the very facility she was sworn to protect, and when the stakes couldn't be higher, she makes the bold move to stand alone in court without legal counsel as Judgment Day arrives. The full trial ran over 5 hours, but I'm sparing you the filler and cutting straight to the madness, the most unhinged clash from the heart of the hearing and the final no escape courtroom collision that you absolutely have to witness.
All right, and let me move on now. I want to perfect the record just in case it wasn't clear during the bench conference. There was an objection made. Ms. Young wanted to go down a line of questioning related to some previous experiences that she has claimed, specifically, I think, a form of assault, maybe references to a lack of therapy. And my ruling was that I had not seen any reason or relevance of that. Those sound like arguments of mitigation of why perhaps you're not as culpable as as the state might allege, that you should receive a lesser sentence if you're guilty of these offenses. But the issues here for the jury to determine are the issues of fact, of whether you did in fact commit any of these offenses. And I haven't seen how a previous sexual assault or a lack of therapy essentially bears on determinations of this at all. But if you want to further argue that or be heard on it, now's an opportunity for you.
When I first hired Leaf Howard as my lawyer, he was told of the instance multiple times. I'm not sure as to why you all didn't get it. I was not familiar at the time of the court's process and who I needed to reach out to. I let him do his job, but it was not to my recollection that they did not know of what happened to me. But yes, there was a night that I went door. Are you asking me to?
No, I don't really. I'm trying to stay big picture, which is what is the reason why the jury needs to hear about this?
Well, I don't know who the person was that came after me. Not only did they come after me, but they had a Polaroid picture of me carrying my son to my friend's house. It had a blue blanket, had me with my black outfit on, and I had on a headscarf that I always wear outside. When I saw that picture in the midst of what was happening to me, not only on the day that Captain Winfrey, I don't know if she's still captain, but at the time, she threw me a baby shower. Even when I first started working there, I was called out by, I believe, Captain Winfrey. Captain Winfrey?
Captain Winfrey is who we just heard from.
No, that was Grady.
Oh, I'm sorry. Excuse me. That was
okay. So yes,
Lieutenant Grady.
It's been a minute. I'm trying to remember names, but she threw me a baby shower at the jail. And when I first started walking there, I was called out for the way that I walked. I walked like I'm a model or twitching my butt or something. And that put me on the spot for everybody in 6 North. So there is no way for me to know if it was because of the baby shower, because she invited my mother and father without my knowledge too. And if I had any knowledge that she would do that, I would not have invited my parents there, because I keep my work separate from my family for this reason. My son was in danger. I was in danger. And there was a instance that happened in the car. But
Honestly, I still have no clue what she's even trying to communicate. She fires off half-finished thoughts like she's drawing random cards from a deck, and none of them line up. One moment she's talking about being attacked, the next she's making wild health claims, then out of nowhere there's a baby shower, a comment about how she walks, and some bizarre story about someone flashing a photo of her child to pressure her into actions she insists never happened. By this point, I'm not analyzing anything anymore. I'm just sitting here stunned, trying to figure out what on earth is unfolding in this courtroom.
Okay, I'm just trying to break this down. Is it your claim that someone from an inmate in the jail or another employee there
that may have
did this sexual assault?
That may have been the one to do. I don't know who the person was.
Where
But being
where
that
did it occur?
I tried calling DoorDash to get in contact to see if I can get it because I called customer service. I parked my car, but I didn't lock my doors. I was having issues with the internet
Let me rephrase. Did this incident happen inside the jail or outside the jail?
outside the jail, but I was working with Fulton County at the time.
All right. So the objection came. You were asking Lieutenant Grady whether he had some awareness of a baby shower and that sort of thing. Do you have any reason to believe that he did?
Because if he's aware of the baby shower,
Oh, no, that's not my question. Not if he is. Do you have any reason to believe that he was aware of the baby shower or your sexual assault?
I would think he does know about the baby shower because they're all connected. They're always talking, having meetings and whatnot. And it was a surprise to me. So it's like, how else would you get my personal information if you maybe talk to my supervisor, maybe talk to my captain? We've had issues in the past as well, nothing detrimental, but I still need to know where it could have came from anybody. It could have came from Captain Winfrey. It could have came from Lieutenant Grady. It could have came from the inmate.
What could have come from them?
If my family was invited to the jailhouse, they could have been followed back. Someone could have been like, here's her information. Because with that situation, me being touched, I was forced to bring whatever they wanted into the jail because they have a picture of my son. Who knows if the next picture might be him at his daycare or me coming into my house. My father.
Okay. I understand. So any position of the state, I mean, I'm just trying to focus on process procedure here.
Right.
The things that Ms. Young is saying, I think that if she chooses to testify, she can go into them.
I agree, Your Honor, but I think at this point, I don't think there's sufficient basis for her to ask witnesses regarding some type of baby shower. I'm just not clear as to the nexus or the sequence of the events that would make it relevant at this particular point in the trial.
Okay. I agree with you there. What we're focused on is, I mean, at this point, I don't think it would be, maybe this additional, I think you said lieutenant that's coming may have knowledge of this potentially that she could ask about.
That is the person who threw the baby shower initially.
The person who's coming next.
Yes.
Okay. Well, glad we're talking about it now then. All right. Well, I think then you can ask this next witness some of these issues. You're going to have to be careful with your phrasing. I think the state's objection to facts, not evidence, is one that could very well come again.
Okay.
And we'll see where that takes us.
All right, so despite the confusion, the judge shows a level of patience most wouldn't and allows her to keep pushing forward with these scattered, disjointed questions. The problem is, she doesn't seem to know who she's even talking about. She's flinging out names and allegations like they're pulled from a spinning lottery drum, and none of it connects to the case in front of her or anything actually happening in that courtroom.
Hey, how you doing? Just stating on the record, I do have the wrong person. This is not the person that was, wrong name.
All right, just for the record, Mr. Miller, can you summarize what exhibits are on the stack that are going to the jury?
What will be going back to the jury will be State's Exhibit 1, which is the oath. State's Exhibits 3 through 9, which are photographs outside of the jail, as well as the posting. State's Exhibit 12, which is the evidence log. State's Exhibits 22, which is the caduceus report. And State's Exhibits 23, 24, and 25, which are the GBI lab test results.
Everything else is going to be held back?
Yes, sir.
All right. I'm going to place the redacted indictment, Court's Exhibit 1, and the verdict form, Court's Exhibit 3 on top of that. And then when we have the consolidated charge as Court's Exhibit 4, we'll include that in the stack. And that will be ready to go back to them when we complete the charge.
And Your Honor, may I place a copy of the oath?
If you've already got it, just make sure you show Ms. Young that before you do so. I mean, it's a bit redundant since it's also Exhibit 1, but all right. So based on what was just said on the record, is there any objection on behalf of the defense as to what would be going back in the jury room during deliberations?
I would say the oath of office. I object to it because that signature, I have to look over my own document again. My signature, if I'm not mistaken, I signed something else. I'm sorry, let me rephrase that. That typed signature, I'm going to have to look at my document and make sure it matches because I'm not sure. I'm not too quite sure if that matches what I actually signed when I started working with Fulton County. And that's all.
All right, let's see how this plays out. The judge, showing patience most people wouldn't, lets her continue with these strange, disjointed questions, but there's an obvious problem. She doesn't even seem to know who she's addressing. She hurls out accusations and references as if there's an entire lineup of characters living in her imagination, yet none of them correspond to anyone or anything actually present in the courtroom.
All right. Well, if that's all, the objection I'm hearing is to the authenticity of this document and whether it should be considered by the jury. That ship sailed when it was admitted, and there was no objection. So those being the only grounds, then your objection is overruled, and Exhibit 1 would be going back. Any other objections?
No objections.
All right. So we're holding in place until we have the consolidated version. That's going to take maybe a few more minutes. Are the parties requesting some additional time to prepare for closings?
We got the state's ready.
I just need a brief bathroom break.
Of course. Do you need a PowerPoint or anything else like that?
I do, Your Honor. So what I would do is I would just take my laptop, if I can, with me to the podium, and I'll just conduct it that way.
You're doing the closing?
Yes, Your Honor.
Okay. And you're opening and closing?
Yes, I'm going to do the close. So defense can go first, and I'll do everything at one time.
All right. So the state's planning to reserve their first closing. And so what that means, Ms. Young, is you'd be up first when we come in and begin closing arguments.
Okay.
And so we'll just take 15, prepare what you need to, practice your PowerPoint, and just let the jury know about 15 minutes we'll be ready to go. We'll be in recess.
Thank you, Your Honor.
1:50.
Yes, the timeless "that's not my signature" routine, always treated like some kind of legal get-out-of-jail card by sovereign types. The problem here is she undercut herself instantly by acknowledging she signed her oath of office in the very same moment, which makes the backpedal impossible. Once that admission is on the record, there's no magic undo button, and something tells me this argument is about to fall flat in spectacular fashion.
All right, we are now back on the record. The time is just before 2:05. It's about 15 minutes past when I instructed the parties to be back at 1:50 to begin closing arguments. The state is present. The defendant is not. I've asked our deputies to search the floor. They have not found the defendant. They've also sent someone into the bathrooms. She is not in any of those. And we are also now trying to make a phone call. The only phone number we have is to her mother, who had previously conveyed a message for us Monday morning to have her here to start trial. And at this point, we're also going to review security footage to see if she walked out of the front door of the courthouse. But looking at her table, it looks like all of the papers and things that she came with are not here anymore. She left a jacket behind. But otherwise, all of her belongings are no longer here, from what I can tell. And we're now well after the time I told her to come back. She has not been spotted anywhere on this floor. And so I believe that she has now waived her appearance going forward through this trial, and we can proceed even in her absence under our case law. I would instruct the deputies at any point, if she shows up, she should be let in, and she can resume being here. But until she does reappear, we're just going to proceed. So, Mr. Miller, are you still ready for closing arguments? Then let's bring back the jury.
So now the jury is brought back in, and with the defendant nowhere to be found, the prosecution delivers its entire closing argument without a single interruption. No defense, no pushback, no counter, just the state methodically laying out its case, start to finish, completely uncontested. She eventually wanders back into the courtroom, but by then the jury has already been sent off to deliberate, and the moment to matter has long passed. At that stage, the outcome is essentially locked in because the damage isn't coming, it's already done.
Anywhere on this floor. And so I believe that she has now waived her appearance going forward through this trial, and we can proceed even in her absence under our case law. I would instruct the deputies at any point, if she shows up, she should be let in and she can resume being here. But until she does reappear, we're just going to proceed. So, Mr. Miller, are you still ready for closing arguments? Then let's bring back the jury.
Is this for me? Judge, is this hers?
I don't know what that is.
This is jury charges.
Yeah, that's hers.
Yeah.
Your Honor, Ms. Boykin just went to the office, but she's on her way back now.
Okay. Well, I think we can go ahead and just put some things on the record that we need.
I need paperwork out my bag if that's possible.
Okay, one second. Okay.
All right, let's go back on the record. And first, I would like to perfect some information we received while we've been here on break during deliberations, which is that I requested
Thank you.
Lieutenant Lattimore to review surveillance footage to try and help us locate Miss Young, and he was able to see some footage. And so I'd like Lieutenant Lattimore to share with us for the record what he was able to view and what he observed, and then we'll go from there. So you can just describe that for me, Lieutenant Lattimore?
Yes, Your Honor. I was able to review footage of Ms. Young exiting the 136 checkpoint at approximately 1:51. And from the checkpoint, she proceeded down Pryor Street, which is south of us, and made a left at Mitchell and Pryor, and proceeded east on Mitchell up to Washington Street, where we observed her make a right turn. And at that point is when we lost sight of her movement.
And this is all through surveillance footage you're reviewing after the fact?
Yes. Your Honor.
And that's several blocks away from the courthouse. All right. Miss Young, where were you going?
Before I answer that, I previously stated that you were in contempt of justice, because of failure or refusal to proceed in equity under exclusive jurisdiction. Did you not acknowledge that we were in equity jurisdiction?
If there's anything else you want to say, Miss Young, this is your opportunity to have it on the record. But I'm really not interested in getting into a back and forth. So if you had some kind of emergency come up or something else you needed to address, that's what I was kind of curious about. But otherwise, we're going to move on.
I did. I needed something to eat. I haven't really eaten since last night. I'm pregnant and I felt like I was about to pass out a little bit. I did kind of forget what time we had to come back. But I got a call from my mother stating that I was supposed to be back in an hour. So that was what took me so long, because I went to grab something to eat and I was going to come back. But after I got that call, I was like, okay, well, he did extend the time. But there was miscommunication there. So I apologize for that, Your Honor.
All right. So I just want to break that down, which is it's now about 4:30, and I think they found you trying to re-enter the courthouse about 20 minutes ago or so closer to 4 o'clock. And so you believe that you got a call from your mother saying you didn't have to be back for an hour. And I think we called around 2 o'clock because we were trying to start closing arguments, as I'd indicated.
If I can look at my phone records, she called me and told me that I didn't have to be back until an hour because the court, whoever called her. And I've updated my phone number, email address in the Odyssey system. So I'm not seeing why I'm getting reports that you all are calling my mother and my father instead of the phone number I gave.
First off, it's not the court's responsibility to babysit your schedule. The judge gave a clear instruction to return at 1:50, and she didn't reappear until 4 p.m., blowing straight past that deadline. At that point, the judge has every reason to doubt she'll stick around to see the trial through, and that trust evaporates fast. So the court acts immediately, issues a bench warrant on the spot, and she's taken into custody to ensure the proceedings continue without any more vanishing acts.
All right. Well, I think we've put your explanation on the record. You can, and so that's all well and good. However, I've lost confidence that we can expect you to appear on time for court proceedings, so I've revoked your bond, I've issued a bench warrant, and so you will be in custody pending the outcome of this trial. More to the present business at hand. No, it's not your turn, Miss Young.
Oh, okay.
I do have Court's Exhibit 5, which I've marked and will tender for the record, which is a question from the jury. It states, and is available for inspection for the parties once I'm done reading it into the record. Is there any statutory minimum for possession of a Schedule 1, Schedule 2, or Schedule 4, respectively, where intent to distribute is presumed if you are in possession in excess of such amount? And it's signed by the foreperson. And so if either party would like to, if the state would like to see it, you can come up and grab it. And if Ms. Young would like to see it, deputies can take it to her.
This is a question from all jurors or specifically?
It's from the jury.
Okay. And though you're failing or refusing to proceed in equity under exclusive jurisdiction, you acknowledge that on the record as well?
All right. My proposed response to this would be
Because you can't
no.
deny that injustice.
And that I would just write on the note, no, and that we would refer them to their previous instructions. Technically, there is a presumed amount, but that's for trafficking, and that's not been charged in this indictment. They asked specifically about the intent to distribute, whether that's ever presumed based on the amount. As I understand it, it is not. So I think it would be an accurate statement of law to say no, and then just refer them to their previous charges. Any input? First from the state.
So they say a minimum, are they referencing a minimum sentence? An amount?
I take the question as a whole. It's a statutory minimum where intent to distribute is presumed. So I know we use minimum in reference to sentences, and that was my first impression as well. But reading it as a whole, it seems to be focused on the evidence of distribution and whether that intent can be presumed based on a minimum amount of drugs. And again, that's where I say the answer to that legally is no. Or actually, I mean, it really just says intent to distribute means intent to unlawfully deliver or sell. So maybe the actual relevant charge would be intent generally, which can be shown in many ways, whether it existed from the proven facts before you. It may be inferred by the proven circumstances or by acts and conduct. So actually, maybe what I would do is say no, and then just reread the intent charge, and then say that they should place no undue emphasis on this charge and only consider it in the context of the charge as a whole.
State agrees, Young.
All right. Any input from Ms. Young?
Yes. So you are not acknowledging the fact that you're in contempt of justice on the record, being that this is equity jurisdiction.
And this is where her sovereign citizen persona really tries to shine, though honestly, it's more like the flicker of a dying bulb than any kind of brilliance. She launches into a meandering rant about jurisdiction, acting like she stumbled onto some hidden legal loophole. Reality check. Courts operate under 3 straightforward jurisdictions: criminal, where fines, probation, or jail come into play; civil, where money is at stake; and equity, where the court can order someone to act or stop acting, like halting construction on a disputed property. So yes, today you actually learned something. Too bad she didn't.
Anything else?
No, I need an answer, because being that I told you that your failure or refusal to proceed in equity, being that you acknowledge the equity jurisdiction, exclusive jurisdiction will constitute in contempt of justice, I've tried to show you as respondent to all complaints and questions because of the legal special relationship that I have paid on this account. I was about to go and e-file it into the system. Are you in contempt of justice? Are you recontracting?
Are you done, Ms. Young? Are you done?
No, I'm not. Are you recontracting the trust?
You remember what I told you at the outset of this trial, which is that if we started getting into
You
it, you
haven't
started
answered the
interrupting
question.
me. All right, Ms. Young, I'm going to find you in contempt of court.
Are you
and
in
I'm
contempt
immediately
of
imposing a
justice,
20-day
though?
sentence, no matter what happens as a result of this trial. And I'm directing you not to interrupt me any further, all right?
You asked me a question, but you didn't answer it.
I'm
So
finding you
trying
in
to see how,
contempt a
as a
second
judge,
time, Miss Young. That is an additional 20-day sentence I am imposing.
you can do as you please, because at the end of the day, you have no jurisdiction. You are in contempt of justice,
Please, if you could
and you
please
cannot
escort Miss Young
refuse.
from the courtroom.
Come
I
on,
find her
yeah.
as
You'll be here in my
disrupting our
fee schedule. Let me
proceedings.
put this up.
I got that. Come on. I'll bring
And
that
you know
back.
you're in contempt of justice. It's okay. You'll be here in my fee schedule.
And honestly, how is the judge supposed to follow anything about this so-called fee schedule when she won't pause for even a single sentence to land? She's cutting off the court, cutting off herself, and somehow expecting that chaotic stack of paperwork to act as a defense. After relentlessly barraging the judge with non-stop interruptions, she earns not one, but 2 contempt citations in rapid succession, like she's speedrunning her own courtroom penalties.
We're back on the record. I've been informed by Lieutenant Lattimore that the jury has reached a verdict, and Miss Young is now present back in court. And Miss Young, I will remind and direct you once again that there are not to be any verbal outbursts, and I'll allow you to perfect the record at the appropriate time, but that is only going to be when I call on you. So with that, we can bring in the jury.
All judges are present, Your Honor.
Thank you, Lieutenant Lattimore. Please be seated, everyone. Members of the jury, I've been informed that y'all have been able to reach a verdict. And if that is the case, it appears that juror number 8 is our foreperson. All right, if you could hand that verdict form to the lieutenant so that I can take a look and make sure it's been completed. All right, and you can hand that back to our foreperson. And sir, if you could now publish the verdict in open court by reading it, you can remain seated and read it into the record.
Count one, possession of a Schedule 1 controlled substance with the intent to distribute. We find the defendant guilty. As to count 2, possession of a Schedule 1 controlled substance. We find the defendant guilty. As to count 3, crossing guard lines. We, the jury, find the defendant guilty. As to count 4, possession of a Schedule 2 controlled substance with intent to distribute. We, the jury, find the defendant guilty. As to count 5, possession of a Schedule 2 controlled substance. We, the jury, find the defendant guilty. As to count 6, crossing guard lines. We, the jury, find the defendant guilty. As to count 7, possession of a Schedule 4 controlled substance with intent to distribute. We, the jury, find the defendant guilty. As to count 8, possession of a Schedule 4 controlled substance. We, the jury, find the defendant guilty. As to count 9, crossing guard lines. We, the jury, find the defendant guilty. As to count 10, violation of oath by a public officer. We, the jury, find the defendant guilty.
And that has been signed, filled in, and dated by you.
Right.
All right, if you could hand that verdict form back to the deputy so that the state may review it as well as the defendant.
Oh, I've seen this.
All right, starting with the state, is there any objection to the form of the verdict, and is there any reason this jury cannot be excused?
No objection, Your Honor.
All right, and over to Miss Young. Any objection to the form of the verdict, and is there any reason this jury cannot be excused?
There's an object.
All
You're
right.
still in contempt of justice, but that's it.
He might be flirting with contempt, but at least he's not leaving that courtroom as a freshly convicted felon with a weird affinity for computer duster. Meanwhile, she's about to find out exactly how much time she'll be spending behind bars for the offenses the jury just slammed her with, and trust me, it's not going to be a quick trip.
All right, we're back on the record for sentencing. I'll begin with the state to present any evidence in aggravation. And let's also start with your recommendation as well.
Your Honor, as the court is aware, the defendant, or the court may not be aware, but the defendant does not have a prior record. However, the state's recommendation in this case is not only based on the evidence in this case, but also based upon the fact that the defendant has not accepted responsibility for her actions and in the situation that she caused at the jail, and the fact that her actions potentially put inmates and other people at risk. For that reason, Your Honor, the state recommends the following sentence. With regards to counts 1 and 2, we believe count 2 would merge with count 1. The state's recommendations on counts 1 and 2 are 15 years to serve 10. State's recommendation on count 3 is 5 years to serve, concurrent with counts 1 and 2. Regarding counts 4 and 5, again, the possession in count 5 would merge with count 4. State's recommendation is 15 to serve 10. The recommendation for count 6 is 5 years to serve to run concurrent with counts 4 and 5. Counts 7 and 8, Your Honor, the state would recommend 15 to serve 10, with count 8 merging into count 7. And on count 9, 5 years to serve to run concurrent. And then for the violation of oath, state would recommend 5 years to serve to run concurrent.
Here's what the state was aiming for: 3 charges with 15-year sentences, 10 to serve, plus 2 more charges at 5 years each, all set to run concurrently. Basically 10 years behind bars followed by 5 years of probation. That's already a serious sentence, no question. But what she actually walks away with? Far harsher, a knockout blow that hits like a freight train. And it gets wilder. Not only was she sneaking drugs into the jail for personal use, but she was also linked to a gang and actively supplying inmates inside. With each new revelation, this case spirals further into chaos, and the most insane part? We're still not even at the finish line. Every detail keeps pushing it to the next level.
In terms of evidence and aggravation, Ms. Boykin, at a prior hearing, you didn't have the case at the time, but it was Mr. Herzog who made representations that this case involved gang affiliation, that there were, and I know that there was a warrant taken out initially in this case about gang affiliation, and that he referenced other evidence showing that she was distributing directly to inmates. And so is that something the state is prepared to introduce in aggravation here today?
Your Honor, the state does have information related to that. We do not have the witness here to testify regarding those matters. Should the court hold a scheduling hearing or a hearing at a later date, we can have that witness available given this time of day.
All right. Well, not hearing a request to continue sentencing and the evidence not...
Would request for the court to continue sentencing to hear from that witness.
And the state's recommendation, though, would remain the same after presenting this aggravating evidence.
It would, Your Honor.
All right. And just by, wouldn't consider it unless we did hear that evidence, but by way of proffer to complete the record, what would be your proffer, what that witness would testify to?
Your Honor, the witness, Raylene Bruce, would testify that she too worked at the Fulton County Sheriff's Department. She assisted Investigator Green with obtaining the defendant's cell phone. A subsequent dump of that cell phone did show that the defendant was communicating not only with inmates, but with other individuals to sell items, to sell drugs within the jail. There are also some Instagram postings for the defendant. And there's also photos of her gang tattoos that were taken at the Fulton County Jail.